Hi, everybody. Okay, it looks like we've got most people in now, so we'll make a start. So, good morning. Thank you very much for joining us this morning for our K3 Hub webinar, Key Myths Busted in Employment Law. For those who haven't virtually met me before, my name's Marie Wadeson, and I'm a Managing Director at the K3 Capital Group, where, amongst other things, I'm responsible for the K3 Hub, which is a member network for professional advisors, which has been developed by a number of brands within our group. Since we launched in the spring of 2021, over 3,500 like-minded professionals from across the country have joined the network, and in fact, beyond the country, as I learned yesterday, through which they access a range of CPD and training sessions, not dissimilar to today's session. So, a few pieces of housekeeping for you. So, as you will have noticed as you've joined the webinar, we are recording today's session. It'll be posted on the K3 Hub website next week. So, if you need to look back, that's where you'll be able to find the recording. The Q&A function is open, so do feel free to ask questions as we go along. Preference is that if you have got questions that you do use the Q&A, just so that we can keep everything together as opposed to using the chat, just so that our speaker can, keep everything together and know where to look. We'll be posting a PDF of the slides into the chat shortly, and then we'll do that periodically throughout the session for anybody who joins a little later on. We're conscious that today is a fairly long session, scheduled for 3 hours, so we will be taking breaks, and we'll be looking to take those on or about the hour. We are running some polls today. They are anonymous and just for fun, so I would encourage you to get involved in those. So moving on to welcoming back our speaker. So I'm delighted to welcome back Toni Trevett. Toni is a qualified HR practitioner, a mediator, trainer and coach. She's a fellow of the CIPD, and she sits part-time to hear cases for the Employment Tribunal Judiciary. Today's agenda, the course today will focus on myths in the following areas: contracts and probationary periods, making changes to terms and conditions, maternity, discrimination, and when employment ends. I think we've got about 25 myths for you in total that will be busted today. Just a quick plug for a few of our forthcoming sessions up to the end of the year. We've got sessions running on commercial property taxes on the 21st of November, navigating capital markets, that's the 7th of November, year-end tax planning on the 5th, and then we've got our always very popular autumn budget analysis and a panel of experts with Jeremy Mindell on the 1st of December. We're going to break convention there and go for a lunchtime session rather than a Friday morning session. So we'll hope that you'll be able to join us for some of those. Your invites will be winding their way to you. You can obviously also visit the K3 Hub website for further details. Just a quick plug also for Toni. She will be back with us next February with an employment law update, and by all accounts there's a lot going on in that, so that'll be an important session. So that's all for me for today, so thank you very much for joining, and Toni, over to you.
Oh, thank you so much. Hopefully you can all hear me and see the slides. I'm sure Marie or someone will tell me if you can't. So welcome. As Marie said, we've got a 3-hour session this morning. So pleased to be able to come back and talk to you about some myths that we want to bust in employment law. So I've had an introduction already, but very briefly, my name's Toni Trevett. I work for a small consultancy called Complete HR Limited, and we work with lots of organisations from big multinationals to small SMEs, training, educating, conducting mediations, investigations, coaching, consulting. So everything in the people management and employment law arena. I also work part-time for the Employment Tribunal Service, which is the part of our judiciary that deals with employment law, whether it's unfair dismissal, discrimination, breach of contract or whatever. And I sit in the South London region, and I've been doing that for over 30 years now, which seems like a very long time. But I have to say I've learnt an awful lot about what employers shouldn't do. There were, I think, over 100,000 cases heard last year alone, and that's putting aside all the ones that settle or get withdrawn, which are obviously a very large number. And the backlog of open cases in the employment tribunals has continued to rise. There's nearly 50,000 cases outstanding at the moment, which is a 23% increase on the previous year. And that means that about 450,000 individuals are still waiting for a claim to be heard. So there's a massive backlog in the system. People wait nearly a year now on average to get a hearing date, even if that's a relatively straightforward unfair dismissal claim. And that's before we have all the changes that Marie alluded to that are on our way, on its way, sorry, in the next couple of years. So I always look at cases, I'm drawn to ones where people behave badly and then try to defend themselves as saying that that was a reasonable decision, when in reality it was utter bonkers. And I came across this case recently, which I thought we'd look at really quickly before we get started. So the headline was, ladies are expected to use a cubicle inside the men's toilets next to the urinals, and this was found to be sex discrimination. Now, who'd have thought suggesting women should use the men's toilet was a good decision in the first place, when the only facility for women was a single cubicle accessed once you'd passed the men's urinals. And in this case, poor Miss Miller worked in a building that obviously had no ladies' toilet. So the council decided to offer the female staff in her building the use of the men's toilets and suggested that they should just put up a sign on the door when the toilet was being used by a woman. But of course, how would a woman know if the toilet wasn't already in use by a man before she goes in to have a look and put the sign up? Anyway, the Employment Tribunal, strangely enough, found that, and this is a quote, any reasonable person would reasonably consider that not having immediate direct access to toilet facilities without the risk of seeing a person of the opposite sex using that toilet was not going to be an appropriate decision. And so the tribunal agreed, probably without very much time, that she'd been treated less favourably to a comparable man, and they described this case as inherent discrimination. Now, this case gets even more bizarre. Not only was that decision really odd, but then they appeal the outcome of the tribunal decision. Why? How would you appeal that and try and defend that it was okay? Of course, their appeal was thrown out by the EAT, the Employment Appeal Tribunal. They dismissed all arguments presented, saying that the tribunal had applied some robust and common sense to determine the treatment this person had been afforded. And there's that word, the common sense word. It features what's reasonable, what's common sense, features in employment case law all the time. Common sense actually means that you have a shared understanding of how to think and behave in a reasonable way to make good decisions. And that's why I never say to people, well, what you should do is treat others as you would like to be treated, because I have discovered over 30 plus years, there's a lot of, quite frankly, bananas people out there. So anyway, on to our agenda. Just caught my eye and I thought I'd share that one. As Marie said, we're going to look at myths in the following areas: recruitment, contracts and probationary periods, making changes to terms and conditions, maternity, other discrimination areas, and we'll look at when employment ends as well. As accountants and business advisors, I understand that you need to be aware of key aspects of employment law to not only support your own organisations, but that of your clients' businesses as well. And do's and don'ts can be quite challenging. People also will talk so factually about and be so sure of themselves when they tell you something as well. So we'll look at some of those most common ones and expose the truth behind them. To be honest, it was quite hard to choose which ones to look at, but I have eventually picked 25 that we'll look at today. Now, I know that sounds like a lot, but we've got 3 hours and that's only about 8 an hour or a bit more. So there you go, we're going to look at 25. I've picked about 9 for a poll, so you can get involved too. It'll be a simple choice of, yes or no, or true or false. So please get involved. It's great to hear what you have to say, and ask your questions as you go along. What I'll try and do is, on the breaks that we have on the hour, is I'll go in and have a look at the questions and see how I can answer them. So onwards then, you'll get the opportunity, as I said, on some of the polls to either say yes, the statement is true and therefore it's not a myth, or no, the statement is not true and therefore it is a myth. So please join in when you see them. So let's go with our first one. An employee must be given an employment contract within 1 month of their start date. So is this true or not? And the answer is nope, it's not true. There is, in fact, no legal requirement to give a written employment contract at all. Although, of course, everyone in reality has a contract, just doesn't have to be in writing. When you do something in return for pay, there's an employment contract. But as I said, there's no obligation to give a written contract. Clearly, it's smart if you do. And smart employers will want to have things sorted in writing, especially if you want to impose kind of specific obligations on employees. What an employer must do, however, is provide a document called a statement of particulars. And this is often the kind of stuff that goes into an offer letter. So it should set out a few basic requirements. And this is all within Section 1 of the Employment Rights Act of 1996, known as the ERA. And this is where most of the obligations are contained. So what the Employment Rights Act says is that you should give a statement of particulars on or before the first day of employment. So no, you don't have to give a written contract, and no, it wouldn't be within 1 month. For any of you that might have thought you had more time, so you didn't have to give it on or before the first day, you've had a slight flashback to 2020 when the law used to say that you had 2 months to provide the written statement of particulars. Why anyone would wait for 2 months, though, was quite frankly beyond me. I would expect people would want to know the full extent of their terms and conditions before they decided to take a job. However, pre-April 2020, you had 2 months to provide that written statement of particulars. If you want to know exactly what you should give, go to ACAS. They've got it set out really clearly. And I've also put it on the next couple of slides for you as well. So it should include the following terms: the employer's name, the employee's or worker's name. So this statement of particulars applies to workers, status workers, as well as employees. And you've got to give the start date, the date when continuous employment starts, because sometimes there's a break in contracts. But if the break is less than a week, then it's deemed to be a continuous contract in any event. Job title or brief job description, the employer's address, the places or addresses where the employee or worker will work, pay, including how often and when. For example, £2,500 a month paid on the last Friday of each calendar month. That's an interesting point. I suggest you write in some flexibility on this. I've got a client at the moment that's run into some financial difficulties, and for several months now has not made payroll on the pay date that they specified. Now, contractually, their contract said we will pay on or around the 27th of the month. Well drafted. So, of course, when the pay didn't go in on the 27th, but went in on the 29th, there was no breach of contract, as the clause said, on or around the 27th of the month. So if you're in a position where you're able to write contracts or change contracts, some flexibility there is a smart idea. Working hours has to be included, including the days the employee or worker must work and if and how their hours of days can change. Again, write in some flexibility. Give yourself the right to change start and finish times or shifts if you have shift workers. Holiday and holiday pay, including an explanation of how holiday pay is calculated. Remember, holiday pay is no longer just basic pay. Where there are regular additional sums received, i.e. overtime or commission or other regular payments, then the holiday pay should include or take account of those as well. You should specify the amount of sick leave and pay, if any. Of course, SSP is your statutory minimum. Any other paid leave, again, as you can see, these can be given in separate documents. Any contractual benefits, again, reserve the right to withdraw or vary those, and any non-contractual benefits too. And then finally, the notice period either side must give, how long the job is expected to last. So is it temporary or fixed term, or is it permanent? Any probationary period, including things like whether you have the right to extend a probationary period and how long it is. If the employee will have to work abroad, any terms that apply to that, and any training that needs to be completed. So there's quite a lot that should go into this statement of particulars. What you can also do is give some documents in instalments separate to that original statement of particulars. But they should be given no later than 2 months after the start date of employment. So you have a little bit longer for those. So as you can see, these can be provided in instalments is the pension arrangements, collective agreements, that's primarily with trade unions, details of any training provided that's not compulsory, and your disciplinary and grievance rules. So if the written statement refers to other documents or steps, then it's important for you to explain to the employees where they are as well as what they are. I had a client years ago, they went bankrupt, unfortunately, although probably not surprisingly, very big organisation in logistics and transport. And they employed lots of thousands of drivers and had a driver's handbook. And I remember them ringing about an issue years ago, and it was because a driver kept dropping his daughter at school in this 40-footer, in this massive vehicle. And of course, unsurprisingly, you're not supposed to do that. So the HR team rang and we were discussing it, and I said, well, clearly this is set out in rules. This person must know and must have been educated and advised that this isn't acceptable. And they said, oh, yes, it's in the driver's handbook. And I said, brilliant. Ideal if that person had also signed to say that they'd read, received, understood, agreed to the terms in the driver's handbook. At which point they said, oh, no, we never give out the driver's handbook. It would be way too expensive. So how is anyone supposed to know what the rules are? So the response to that question was, it's in each of the depots. They have depots all across the country. And I visited at least 3 depots in the next month for various reasons, and of course, never found a driver's handbook. So if we've got rules, we need to tell people what they are. So what's the penalty or risk if you don't provide the statement of particulars in the form that you're required to? Well, there's no freestanding right to compensation if you don't provide this Section 1 statement, but an employee can receive compensation for a breach of this obligation if they have other claims that are successful. So if someone brings an unfair dismissal claim and they are successful, they may also add in compensation for the failure to have been given this document. So that's the Section 1 statement of particulars. Some employers also believe that if they don't put anything in writing, it gives them much greater flexibility. But this is incorrect. The lack of written documentation causes more uncertainty. And where there is uncertainty and a successful claim, then it's the tribunal who gets to decide what the terms were or should have been. So I would, ensure that you put things in writing and you're really clear. The good thing about contracts is that you can include provisions that go much further than what the statute says. So if you want to have provisions about confidentiality or provisions about, restrictive covenants and clauses after employees leave, then you need to have a contract. And in the event of a dispute, the tribunal will look at what's in writing and what's been clearly agreed before they start looking at what might be implied in the arrangement. So I've just put up here what the benefits are of a well-drafted contract, and I think these are pretty straightforward. So it allows you to have a greater degree of control in relation to expected standards of performance, a greater degree of protection for the business. As I said, those provisions that you might want to add into a contract. It provides the employer with greater degree of flexibility if you want to vary things, and you can impose more extensive obligations on employees over and above what the law requires you to do. So if you want longer notice periods, you would put that into your contracts. And just finally on this, in July 2025, the government announced that it's going to publish a new consultation on non-compete clauses. So we've had consultation before, which ran its course, and then we were told legislation would follow when parliamentary time allowed, and it never allowed. So it didn't happen. So this follows the previous government's consultations to limit the length of non-compete clauses. to 3 months, and this was in a bid to boost, competition and innovation and give employees more freedom to change jobs. So what all we know at this point is that there's going to be more consultation, so potential reform on this area in the horizon, but I have no detail to give you of whether it will still be consultation about a limit of 3 months, when it will take place or what it will look like, and so on. So this is a watch this space point. So the final thing is, should you sign your contract? I think it's another myth where people think no signature, no agreement. But the absence of a signature doesn't automatically render a contract unenforceable. In some cases, an employment contract is implied through the actions and conducts of the parties. So think about a new starter. You send out the contract with the terms and conditions specified. You say this is the terms that will apply, and you start work on X date. You'll get paid on Y date during that month. Well, if the employee starts and they do their work and they get paid on the date that they were told they would be paid, whether they've signed the contract or not, it's pretty clear that by their actions, by the behaviours, that they've accepted that this is the terms of their contract. There was a case a while back, Wes and Science Museum Group, where Miss Wes had been working for an organisation for like 20 plus years, and they changed her notice period down. So it used to be 6 months and it was reduced to 12 weeks. Another change was made to her job grading. So she's given this new contract. She appeals the job grading point, but she says nothing and raises no objection to the notice period change. She continues to work for a further 9 years, but doesn't sign the new contract. She's eventually dismissed. She's given 12 weeks notice. Remember, it was 6 months. They reduced it to 12 weeks. And she brought a claim saying, I didn't sign the contract. I never agreed to that. However, the tribunal found that she had not worked under protest at any point. She hadn't queried it. She knew what it had been changed to, and therefore she had, by her actions, accepted it. Now, other cases might have different outcomes. So my advice when you want to make changes, particularly those that are detrimental, or where you ask for a signature, get proper advice on it. And if you ask someone to sign it, make sure that you follow up and get the signature. Okay, so that's myth 1. Let's look at myth 2. Where an individual has accepted an employment offer but not started work, the employer can withdraw the offer. Where, for example, there's a change in circumstances, a freeze on recruitment, and we can no longer employ this person. So can you withdraw it after someone has accepted it but not started? Well, yes, you can. It is true. You can withdraw it, but it's going to cost you to do so. So imagine the scenario: you find this great candidate after extensive recruitment. You offer the person a job, maybe verbally, and they say yes, that's great, and then you change your mind, or maybe you do some reference checking and it's no good, or there's sudden pressure on your bottom line. What the law tells us here is that withdrawing a job offer is entirely possible, but what does the terms and the contract say if you choose to do so? Because if you make an offer and it's accepted and then you withdraw it, then the contract is in place and you would have to at least pay notice under the contract. If you make an offer and it's not been accepted, so you've not heard back from the person, it's no problem at all to withdraw it. The contract hasn't been completed. The offer has been made, but there's been no acceptance. So, of course, you can withdraw it without any problem at all. Of course, if you want to withdraw a job offer because of a discriminatory reason, you find out someone's pregnant, you find out they have a disability, then of course there's going to be a clear case of discrimination. There's no minimum qualifying service period required for an individual to claim discrimination. And that's why it applies to people even before they've been given a job with an employer. So back to this myth then. The statement says they've accepted the job, so the contract's been formed. So what's the position here? Well, you can withdraw it, but as I said, it will cost you. And there is a difference between something that's called a conditional job offer and an unconditional job offer. So let's talk about those briefly. Conditional job offers are where the applicant has to firstly satisfy certain requirements. So conditional job offers, often they will have things like, you've got to have satisfactory references, or you've got to pass a criminal records check, or you've got to prove your academic qualifications or your right to work in the UK. So conditional job offers have conditions attached to them. The position is different where there is an unconditional job offer because there are no conditions. So as soon as it's accepted, then the contract is made. Okay, so you can still withdraw a job offer on a conditional contractual basis if the conditions aren't satisfied, aren't agreed to in a satisfactory format for you. So always, in other words, make your job offers conditional and set out what conditions apply, because the contract doesn't crystallize until those conditions are satisfied. So what will it cost? Well, it's a bit of a common misconception that there is no cost if you rescind an accepted job offer. The financial liabilities for breach of contract in this context can include, obviously, the notice period or notice pay. You wouldn't be giving a notice period because they haven't actually joined you, but you'd have to give notice pay. But the claimant is also entitled to recover damages for any losses suffered in consequence of this situation. So that means if they had resigned from their previous employment in order to take up that job offer, they could be entitled to damages, maybe even over and above the notice period if you have withdrawn that job offer. So it's also important to specify what the notice is. Often in probationary periods, there is a shorter notice period given. However, rescinding a job offer can, often where there is no probationary period, mean that full notice periods are, full notice is payable. So make your job offers conditional, specify how much notice would apply, and you can even have no notice in the first month of someone's employment. So the statutory minimum is for no notice in the first month. So this is a case of McCann and Snowzone Limited, where the tribunal provides some useful guidance on the approach that you should take. In this case, Mr. McCann attended 2 interviews following a call from the recruitment agency that he had made his application via. The recruitment agency gave him a verbal offer, which he accepted. Now, Snowzone later denied that a formal offer had been made. And so Mr. McCann brought a claim for breach of contract at the Employment Tribunal. And it was held in this case that by the tribunal that Snowzone had acted through the recruitment agency and had advised them to make this verbal job offer, which had been accepted. Accordingly, the contract was created long before the person started work, so it can only be terminated by giving notice. And he was entitled to a reasonable period of notice of 1 month, and he was earning £32,500, so he got £2,708 in damages, plus his tribunal fees at that point. So be thoughtful about when you want to make an offer, what conditions you want to apply, what the notice period should be, and make sure that you've thought through in case you need to withdraw it. There was also, as I mentioned, the added risk of discrimination. So if you withdraw a job offer and it can be linked back to one of the protected characteristics and is therefore an act of discrimination, then of course the damages are further increased. And in this case, a mum won her claim and she was able to win £90,000 in a sex discrimination case after this employer took away her job offer when they found out the age of her children. So Mrs. Lee was quizzed apparently out of the blue about how old her children were, despite it having absolutely no relevance to the job at all. And they then rescinded the job offer. I think she was earning £68,000 or £69,000 a year. She had resigned from her previous job to take up the new role. She had answered the question, so she was asked about her children and she said they were 4 and her youngest was nearly 1. And a few days later, the job offer was withdrawn. And at the tribunal, the employer claimed that they only withdrew it because there was a freeze on headcount, and that had come directly from their head office. and the questioning about her children was just to build rapport. But the employment judge didn't accept that evidence and ruled in her favour and said a man would not have been asked the same question. So she was awarded, I think, about £92,000 in the end. So few learning points there. We need to think about the questions you ask in an interview. There's definitely no room for asking people about their personal circumstances, their children, their desires to get married, or any of those kind of things. You'd think we'd kind of got to a point where those sort of questions weren't asked, and there you go. Here's a case where it was. And also, as I said, all the points about conditional job offers. Okay, myth 3. An employer can reject a candidate for a 3-month maternity leave cover role on the basis that she's 8.5 months pregnant and would not be able to work the full 3 months. So can an employer, is it true that they can reject a candidate who's supposed to do maternity leave cover because it's short period and they are pregnant? What do you think, true or false? I'll let you have a second to answer. At least it's easy choice. So the answer is, there we go, 65% of you say it's true that you can reject a candidate in those circumstances, and 35% of you say, no, that's false. Well, on this occasion, the 35% have it. It's not true. So often in employment law, there's a lack of clarity, and it's often all about the word reasonable, and given the circumstances, it could go either way, but not in cases like this. It's really, really clear what the law says. Failing to recruit a woman on the grounds of her being pregnant, even if the contract is for a fixed term period only, even if she'll have the baby before she would be due to start, even if she's covering someone else's maternity leave, will always constitute unlawful pregnancy discrimination and can never be justified. And there was a case years ago, in 1994, Webb and EMO Air Cargo UK Limited, and this is where it was a maternity cover role, same circumstance as this question, and Mrs. Webb was the successful candidate to cover the person off on maternity leave. She learned she was pregnant 2 weeks after she started the job. And she was dismissed after notifying the organisation of her pregnancy. So it can never be a reason to justify turning someone down for a job. Good. Okay, so for once, there's a straightforward one. Okay, myth number 4. An employee does not begin to accrue service for the purposes of their statutory rights until they have completed their probationary period. This is not true either. Probationary periods have no meaning in our employment law at all. They're just not mentioned in the Employment Rights Act anywhere. So the existence of a probationary period is a contractual matter, and it therefore does not affect any new employee's length of service for any statutory employment rights. Statutory rights include things like unfair dismissal rights, or the right to receive redundancy pay, or, maternity pay, or any of those things. Often these things are dependent on a minimum period of service based on, joining date, but it's based from original start date, not from any date that marks the end of a probationary period. So again, this one's quite a straightforward answer too. Another probationary period question I often get asked is where an employer states that they have a probationary period, do they have to wait until the end of that probationary period before they could dismiss someone as unsatisfactory? So if you say we've got a 6-month probationary period, are you stuck with that person for the full 6 months before you were able to say that they weren't satisfactory? And the answer is no, unless you've drafted your probationary period clause to say that, and I can't see any reason why you would, then you wouldn't have to wait until the end before dismissing someone. But you would have to give notice to terminate their employment in accordance with the terms of their contract or the statutory minimums, or you have to make a payment in lieu of contractual notice if you don't want them to work it. So I think you should clearly set out what the length of a probationary period is, when and how it will be reviewed, if it can be extended, and if so, for how long. Just state what the terms of the probationary process is. The contract should also set out the notice period that you're required to give. And I think, as I said earlier, often in probationary periods, it can be much shorter. There's always the statutory minimum, so it can be no notice in the first month, but then from 1 month to 2 years, it's a week's notice, 2 to 3 years, 2 weeks notice, and so on, up to a maximum of 12 weeks notice after 12 years service. That's for the employer to give the employee. The employee, under statute, only ever has to give 1 week's notice to the employer. Of course, unless you have a contract that says otherwise. If you're terminating the probationary period because of gross misconduct, then as in all gross misconduct cases, no notice is required. You still have to follow a fair process and investigate, and so on. So even though employees usually need 2 years service to claim unfair dismissal, if you dismiss in the probationary period for a discriminatory reason, then as I mentioned before, they would be able to bring a claim for discrimination as no minimum notice is required. Okay, still on probationary periods, I think we've got another poll question now. So the probationary period clause states that it's 6 months in duration. During the probationary period notice, it is 1 week after completion. Sorry, during the probationary period, notice is 1 week, but after completion of the probationary period, it is 1 month. The employee is on annual leave when their probationary period is due to end. We therefore had to hold their review meeting on the first day back to work. So in other words, even though they'd failed, we didn't tell them within the probationary period because they were on holiday. So we terminated their employment with 1 week's notice. So would it be lawful or unlawful? Hopefully, if you reread that question, it will make sense. Probationary period is 6 months. During the probationary period, it's 1 week's notice. After successful completion, it's 1 month's notice. The employee is on annual leave when their probationary period was due to end. So the review meeting wasn't held until they came back to work after the probationary period had finished. They failed their probationary period and were given 1 week's notice. Is that lawful or unlawful? So I'll give you a second to say whether you could or could not do that. Could you get away with a week's notice? So here we go. 24% of you say yes, you could. That is lawful. You could just give the week's notice. And 76% say no, it would be unlawful. And this time, the majority are right. The 76% have it. This would not be lawful. If you fail to identify whether the employee has passed or failed by the end of their probationary period date, then it will be assumed that they've passed. So you have to have some clever wording here if you want to be able to take longer to let someone know. So accordingly, in the scenario I gave you, 1 month's notice would be due, not 1 week's notice. And it may also be that certain policies and procedures would also apply, like performance, underperformance, or capability. Often those policies will say that they're only applicable to employees outside of the probationary period. And therefore that reserves an employer's right to have a minimal or minimized or shorter process than they might do otherwise. So what should the employer have done in this scenario? Well, either extended the probationary period, said to the person, I notice you're going to be on leave when we should have done your probationary review, so we're going to extend it until your return, or hold the meeting early, do it before they went on annual leave. So well done, the majority got that one. Okay, here's how not to do it. So in this employment tribunal case with London Borough of Hammersmith and Fulham, the claimant suffered from in this case, with the London Borough of Hammersmith and Fulham. The claimant had ADHD. Sorry, I'm just getting my cases right. My head had ADHD and was also later diagnosed with PTSD. They had been involved in the response effort to the Grenfell Tower disaster, which was obviously clearly greatly distressing. And this claimant started this role as a public services reform director, so senior role. Upon her line manager becoming aware of her ADHD diagnosis, she says the line manager's attitude towards her started to change. She had a probationary period of 6 months. After the 6-month period had passed, the council tried to extend the probationary period by another 3 months and backdated a letter extending it to give the impression, although wrongly, that the extension had taken place before the 6 months was up. So lots of red flags here. Anyway, so they extended this probationary period, and at around the end of that extension, she tried to raise a grievance. So what the council then did was backdate a dismissal letter to make it look like they dismissed her before the date she'd raised a grievance. I mean, this is really how not to do it with bells and whistles. So it goes to tribunal, and it's not going to surprise you to hear that the council was found to have discriminated against the claimant by reason of her disability. The tribunal decided that the decision to extend her probationary period and the attempt to do so after the expiry of it was also an act of disability discrimination. Well, hold on to your hats, because this claimant was awarded 4.5 million in compensation. Most of that was made up of loss of earnings and pension payments. The size of the award was definitely reflective of the fact that this was a very high earner with very good pension entitlements, but she also was awarded a significant sum for injury to feelings, personal injury and aggravated damages because of the discrimination she'd suffered, and the lying, the backdating letters and so on, had a major impact on her health and her career. So a huge sum of money, and this is for someone with very short service. It's worth noting that most successful employment tribunal claims do not result in compensation of 4.5 million being awarded, truly an exceptional sum, but they do result in compensation of reasonable sums being awarded. So the lessons here: dismissing an employee for failing to pass their probationary period is not risk-free from discrimination or whistleblowing risk. Be very careful when you're dealing with people with a disability. Be aware that where an employee is disabled, you're required to make reasonable adjustments to how you manage that person and their probationary period. Word your employment contracts really carefully about giving you the right to extend or review outside. So that's definitely a lot of lessons in what not to do. Here we go. Next one, myth number 6. An employee has the right to have bank holidays off work or to be paid overtime when they work them. So do employees have the right to either time off or pay for bank holidays? And the answer is no, not true. That's a myth. Although widely observed throughout the UK for many employers and employees, no one is automatically or entitled by statute to get a day off or extra pay on a bank holiday. The right for that depends entirely on the contract of employment. When statutory minimum holiday rights were introduced, people were entitled to only 4 weeks leave per year. And that was increased shortly afterwards to 5.6 weeks per year to make sure that we incorporated bank holidays. So you have to look at what your contract says as to whether your bank holidays are part of your annual leave allowance or in addition to your annual leave allowance. But this one's a myth. There is no statutory right to pay or time off. Okay, number 7, still thinking about holidays. If I am sick while on holiday abroad, I am entitled to have the days of holiday lost to ill health returned to me. So if I'm sick, I can have the days back. This is the concept of annual leave refunds. So we've got a poll for you. What do you think? Is that true or false? Let's take a second to make your decision. What do you think? True or false? I was pretty even split for this one. So 46% say that's true. You are entitled to your holiday to be refunded, and 54% say it's false. Well, this time it's the minority, although you're pretty even, that are right. It is true. You can have holiday refunded, but an employer is probably going to want to have some sort of process in place. Otherwise, what's to stop an employee saying, oh, while I was away on that stag do in Magaluf, I ended up feeling really unwell and stayed in bed for 2 days. So I need those 2 days added back onto my holiday allowance. Well, there's some key case law that sits behind this refund concept that has made this a legal requirement. There was a Spanish case of Pareda, and then there was a UK case of NHS Leeds versus Lana. And taken together, the law as it stands is that an employee who is ill during a period of holiday is entitled to transfer those days when they're ill to a period when they return from holiday. And if this cannot be achieved before the end of the leave year, they get to also carry it over into the next leave year. There was also an appeal case a few years ago, Plum Duncan and the Print Group, which found that any carried over leave needs to be taken within a further 18 months of the start of the new leave year. So there's a limit. Once you carry it over, you have to use it within 18 months. So instead of taking holiday for the period that they're sick, they are instead marked as off sick and entitled to sick pay, whether that's SSP or contractual sick pay, and they get the holiday back. But as always, the most robust way to keep this under control, I would suggest, is to have a very clear policy in place, setting out what your position is should someone fall ill or be injured, either just before or during a scheduled holiday. Obviously, as in with all contractual clauses, the clearer you are, the better it is. If you've got questions over someone's honesty, or if you strongly suspect that they've abused this holiday refund process, then you could pursue disciplinary action. However, you've got to have proof. And it would be very difficult to evidence misconduct if someone were abroad at the time it happened. So I think, probably most effective to put in place some deterrents, maybe limit access to contractual sick pay and instead say we pay SSP only if an employee falls ill while on holiday. Or another option might be to pay SSP only unless the person was, hospitalised and unfit to return home, for example, and has medical evidence. So you can insist on a medical certificate for company sick pay to be produced for any sick pay whilst on holiday. So there's lots of things that you can write into a contract to be a deterrent for abuse for this. Equally, making it clear that absence occurred in this way still counts towards any trigger points might also be another deterrent. So if you say, after 3 absences or, 8 days, that's a trigger to an absence management process, I would, make it clear that absence on holidays goes towards those triggers as well. So how you record and monitor sickness absence will help identify any abuse of the system. Should it become a regular occurrence, that might be a red flag, and you might look further into a particular employee's circumstances. Often employers also ask people to produce a company doctor's fit note for any period abroad as well, but that seems to be inherently more difficult. So yes, they can have it back. Why do I have a shark photo? Well, a while back, there was another great headline grabbing case, and it was man hailed hero after grappling with shark in Australia, but was sacked after it emerged he had been on long-term sick leave for stress. So this was Paul Marshalsea, who waded into the surf and grabbed this 6-foot shark by the tail because it was swimming right on the beach and where there were paddling children. And this person claims he risked his life on this beach outside Brisbane. Well, as it so happens, there was a local news crew that were on the beach that day and actually caught these exploits on film. And his story made headlines all around the world, including Australia, and earned him a great deal of praise from lifeguards and so on and so forth. I think you can probably still Google it and watch the news report. But his employer also got to see this news report and decided that he should lose his job because he was off work at the time on long-term sick with work-related stress. So he had gone on this holiday with his wife. They both worked for this charity, and off they went to Australia. However, when they flew back and arrived back in the UK, there were letters on the mat informing them that they had been dismissed. And he was interviewed by the BBC and was, recorded saying how disgusted he was by the way he'd been treated. And he said, "What am I going to do now for employment, as there's not much call for shark wrestlers in Merthyr Tydfil?" The letter he received actually said, "Whilst you were too unfit to work, you seem to have been well enough to travel to Australia. And according to the recent news footage in Queensland, you grabbed a shark by the tail and narrowly missed being bitten by quickly jumping out of the way." And a follow-up letter also said, "This has been a fundamental breakdown in our confidence and trust in you and in your ability to perform your role, and therefore dismissal is the only course of action." Now, he responded to say, "Well, if I hadn't gone in to save the kids on the beach that day, I would still have a job. This is a children's charity. You should be patting me on the back and congratulating me, but sacking me without any form of discussion is quite frankly disgusting." He had 10 years service and he had been advised by his doctor to take a vacation. So the employer essentially thought he was lying about being stressed or too stressed to work. But obviously, these aren't the same things. This is although they presented it as a misconduct dismissal, it surely can't be, especially when the doctor had recommended that someone take a vacation. So no law against an employee going on holiday whilst they're off sick. The doctor had signed them off clearly for work-related stress. They had been advised to, do things that make you happy, go on holiday, relax. And that's the whole point of, the time off. So employers definitely, employment tribunals, would definitely not like an employer who thought that they knew better than the doctor. As it happens, they settled out of court, so we don't know how much he won, but they definitely would have lost. Of course, it would be different again if he was off sick for 2 broken legs and was seen jumping around in the surf, wrestling sharks, but work-related stress, not the same thing. So don't be hasty. Right, next one. We've got a TUPE question. Myth number 8. After 3 months, it is safe for a transferee employer, so that is the new employer, to vary the contracts of TUPE transferred employees in order to harmonise terms and conditions with existing staff. So you can make those changes as long as it's after 3 months from the date of transfer. So quick recap of TUPE legislation if you're not familiar. TUPE is the Transfer of Undertakings Protection of Employment Regulations, and that gives employees that move from one employer to another under a TUPE transfer the right when they move to have protection for their length of service as well as their pay, holiday and other terms and conditions. Employees who have transferred, however, may often have different pay and terms and conditions to existing employees in the new organisation. So they may end up doing the same or similar work with new colleagues who are paid differently or receive different benefits. And that, of course, can cause all sorts of employee relation difficulties and employee dissatisfactions. I'm doing the same job as X, but I get paid less. So often new employers want to even things out and harmonise. So back to the question, can you do it after 3 months? The answer here is no, you can't. There is no limit on how long TUPE protects employees' pay, terms and conditions, and definitely nothing that says you can make changes after 3 months. In fact, changes made that are connected to the transfer are not enforceable even if the employee agreed to them. So we've got this very strange scenario where someone could say, okay, yes, drop me, £2,000 in my pay, and then later would be able to claim because they're not able to agree to a detrimental change. The only circumstances where you could is where the contract of employment expressly permits the variation and the exception is construed narrowly to cover changes such as, the right to change your place of work, for example, rather than a general provision in a contract that says we can vary any terms and conditions, because that, of course, would damage the trust and confidence. The change also would have to amount to something that's called an ETO change, which stands for an economic, technical, or organisational change. So if you can show it's an ETO change, which entails changes to the workforce, and the employees agreed to them, then you could rely on it. So this is a really technical area. CPD is very prescriptive as to what you must do and what protection it gives employees. And then if you want to make changes after a CPD transfer, that becomes even more difficult. There is ways to do it, but it's tricky to do it. Of course, in practice, the longer the time period between the date of the transfer and the changes you want to make, the harder it is for an employee to show that the reason for the change is actually the transfer and not any other reason. There was a case where a change was made 2 years after a transfer, and that was still found to have been unfair because it was transfer related. So let me give you 2 examples to bring this to life a little bit. So here's example 1 where the organisation had a valid economical, technical, organisational reason for a contract change. Princeco, large printing organisation in Luton, buys a small organisation called Media Limited. 27 employees at Media Limited transfer to Princeco. Most of the technology at Princeco is more advanced. The work can now be done by fewer employees. So Princeco restructures its organisation and makes 5 people redundant. It carries out the proper processes, consulting effective employees, and so on. And they agree to change their contracts to work from one location to another as part of the restructure. Now, that is a valid ETO reason. There's an economic, technical, and organisational reason to require people to move location, and they are asked to do so because of that ETO reason, and they agree, and there is a change in the workforce because 5 people are being made redundant. So that is when it would apply. Okay, hopefully that's helpful, but my overriding point with anything CPD related is, unless you're really confident, make sure you get some good advice. Another question I'm often asked when it comes to CPD is where a new employer has no need for all of the employees transferred, can they select who should be made redundant just from the transferring people, or do they have to also look at their existing workforce? And the answer to that, again, is yes, they have to also look at their existing workforce. So, imagine the scenario, you have 3 payroll clerks, you take on another company, what transfers in is another payroll clerk. So now your payroll team is 4 people, 1 CPD across, 3 originals, but you don't need 4 people. You can do all the work with 3. Can you just pick the person who transferred as the redundant one? And the answer is no. You would have to pull all 4 people and go through a fair redundancy process. So you can't just pick the new person. Forgetting CPD for a second, just thinking generally about changing contracts, we'll look at myth 9 when we come back from a short break. It's 10 o'clock. So let's have 5 minutes. Hopefully that's long enough for a super quick comfort break. And then we'll look at number 9 when you come back. Thank you very much. Everybody, hopefully you've had enough time for a super quick break. I thought before, hopefully you can hear me and see the slides still. I always worry when I do anything, whether it will all just disappear. I'm sure someone will tell me if you can't. So I've had a few questions and I've had a chance to quickly open it and have a look. So first one says, if during a probationary period, a member of staff is diagnosed as being autistic, what steps should an employer take to support and adapt the training needs for that employee? So that's the first bit of the question. So this is someone being diagnosed as autistic. What support or adaptations for training needs in particular should take place? This is where we need to speak to the individual concerned and have like a really, great conversation about what the disadvantage is that that person has, how that impacts them, and what we can do to make some reasonable adjustments to support them. The National Autistic Society, I think I've pronounced that correctly, has great advice on reasonable adjustments for adults with autism at work. So do go and have a look at the National Autistic Society. I'll try and in our next gap, I'll put in a link for that person. But there's some really sound and positive advice. But this is where you talk with the individual and find what those reasonable adjustments might be. And then the second half of that question was, if at the end of their probationary period, that person is considered as needing improvement, but has not been given any support since their diagnosis, is there anything the staff member could do? Well, I would definitely appeal that needing improvement analysis and or raise a grievance, but speak to the employer. If this is someone's personal circumstance, speak to your employer, set out what's happened and how it's impacted you. Go into detail about the needing improvement. Does it link to the autism or not? Because it may not do. But you've got options there to raise concern or raise a grievance if dealing with that more informally doesn't work. Okay, thank you for that. Hopefully that's helpful. If not, put another question in and I'll give you some more information. The second point was, or the second question, sorry, was, is ad hoc, i.e. not regular, overtime, maybe overtime that comes in 5 months of the year, and it's also the employee's choice, so it's not compulsory overtime, would that still be included in the holiday pay calculations? And the answer, I believe, is yes, it would still be included, because remember the reference period over which you look at pay is now 12 months. It's a 52-week reference period. So if it was non-compulsory overtime, but was regular, as in your example says it does take place over 5 months of the year, I think that would be caught and should be calculated in holiday pay. ACAS have a good holiday pay calculator that you can use. I think gov.uk have one too. So also go and have a look there as well. And then the final question was, for a conditional job offer, can you withdraw it before all the conditions have been met by the potential employee? So that's an interesting one. So where you've got a conditional job offer, until the conditions are satisfied, the contract doesn't crystallise. But if you withdraw the job offer before the conditions are satisfied, so you don't know whether they would be satisfactory or not, I would, to be absolutely crystal clear, ensure the contractual drafting includes the ability to do that with no notice payable. But conditional job offers are until the conditions are satisfied, the contract doesn't crystallise. So yeah, potentially that's possible. Good. Well, I hope I've answered those. And if not, as I said, do come back to me. Let's go back to myth number 9 then. So we've forgotten TUPE, thank goodness, because TUPE is highly complicated. And we're thinking more generally about varying contracts. So the myth was you can never change a contractual clause or term without the individual employee's agreement. Some people would say, otherwise, what's the point of a contract? What's the point of having a signed contract if you can just change it? Well, you can make changes to contracts without the employee's express agreement, but it's not easy to do it. Generally, an employment contract can only be amended if the contractual terms permit it. So there's variation or mobility clauses, or that the change is embedded in the contract itself, or if the parties agree to the change. So getting an employee's agreement is by far the best option. And sometimes you pay to get that. So there are sweeteners of some sort to get people to agree, or you buy out a term with a sum of money or with another benefit. Of course, it's better if employees are happy to accept change. If you are making beneficial change, then an employee is never going to reject that one. So those changes can be made without agreement. You give someone a pay rise, you don't ask them if they'll agree and change the contract accordingly. Any correspondence setting out changes will probably be deemed to be incorporated into the contractual terms and conditions without you ever needing to issue a new contract. Difficulties, however, arise if you want to make changes which the employee doesn't want to accept. So they think they're detrimental. So maybe you want to reduce their pay or change their location or change their holiday. Simply giving the employee notice of your intention to make a contractual change will not remove the risk of the employee bringing a claim against you for breach of contract, or if it's sufficiently serious and they leave, constructive dismissal. But you can make changes without consent in two particular ways. So firstly, an organisation can just impose change, can just say, we're making this change. They just do it and see what the employees do about it. Secondly, an organisation can dismiss and then re-engage on the new contractual terms. And each of those two routes comes with risk. Imposing a change without consent, a unilateral change of contract, allows an employee to either continue to work but specify they're doing so under protest and then possibly bring a claim for breach of contract, or if it was lower pay and unlawful deduction from wages. If the breach is fundamental, then they can resign and claim constructive dismissal, or in some circumstances they might simply refuse to work under the new terms or to accept that new term. And the alternative route is to dismiss and re-engage. So this is where an employee doesn't consent to the change, but maybe it's not appropriate to just impose it, or the employer doesn't want to just impose it. So they go through this dismiss and re-engage process. It's a cleaner and simpler way to change terms, but it's not risk-free from unfair dismissal claims. You need to have a potentially fair reason for what you're doing, and it needs to be a business reason. And then you need to show that you acted reasonably in the process you adopted, i.e. consulting, giving time for people to respond, giving proper notice of the change, and all those kind of things. A dismissal following a failure to agree to a change in terms and conditions will almost always be unfair if there hasn't been any good, decent, fair consultation process. Even if your business is faced with massive financial difficulties, discussion should still take place about the reasons, how it will affect people, what the consequences are, seeking agreement, listening to responses, and then explaining that if they don't agree, that you'll do the dismiss and re-engage process. It's also very important to determine how many people are affected by the change, because if 20 or more people are impacted by a change of a contract, then there's an additional obligation to do something called collective consultation. And this is where you have to either consult with a trade union if you recognise one, or you help your employees create an employee body for you to consult with. So again, 20 or more people affected, look up collective consultation obligations and follow those. And the dismiss and re-engage route is often known as the fire and rehire process. So you might have heard of it being referred to in that way. Last year, 18th of July 2024, the government introduced the very first statutory code of practice on dismissal and re-engagement. And this code imposes the expected procedure employers will follow if they wish to use this fire and rehire process. And that statutory code says it should be a last resort following meaningful consultation with employees or their representatives if you're in the collective 20 people plus category. And the code also says that employers should now contact ACAS before they raise the prospect of dismissal and re-engagement. And if you fail to comply with this code and people win in the tribunal, you can end up with a 25% uplift in awards to employees. There's also new legislation coming from the 1st of October 2026, and I'll talk more about this next February. If an employer wants to use the rehire process, there'll be even more restrictions. So if you're thinking of going down that route, then get some good advice first. Another one I often hear, similar to this, is you can vary an employment contract term as long as you give 12 weeks notice. Again, that's a myth. Making changes to an employee's contract is not possible just by giving lots of notice. So everything I said before applies, even in circumstances where you give maximum notice under the contract. 12 weeks is quite often the maximum statutory notice in any event. You are still ending someone's contract and starting another one. So you're still effectively dismissing. You've got to go through the fair process. So just giving 12 weeks notice would not render that a fair process. Okay, myth number 10. An employee's entitlement to notice when ending their employment is based on how often they're paid. So if they're weekly paid, they get a week's notice. If they're monthly paid, they get a month's notice. Well, I've told you what the statutory notice is already, so hopefully you'll realise that this is not true, although I hear it all the time. Oh, they're monthly paid, they're entitled to a month's notice. It's irrelevant what the intervals of payment are to someone's notice period. As I said before, if they've worked for you for 1 month or more, then it's 1 week's notice up to 2 years of employment, unless the contract says more. The contract can't say less. Gross misconduct, no notice. Okay, myth number 11. So at interview, a woman has a legal duty to disclose she is pregnant, just as a person with a disability must. So do people who are either pregnant or have a disability, are they required, do they have a legal duty to disclose that? And the answer to this is no. Women who are pregnant have no legal obligation to disclose they're pregnant during the recruitment process for a new job at all. Employers can actually leave themselves exposed to potential claims of discrimination if they ask an applicant in their interview about, goodness knows, I hope no one ever says to someone, are you pregnant? That's just full of difficulty. But even to ask someone whether you're married, planning to have children, do you have children, what their ages are, I've given you that case already where that was asked. We shouldn't be asking non-work related questions. I did have a client a while back who said to me, I was doing some management development training. We were talking about recruitment and good interviews, interview questions and so on. And I made this point, there should be no need to ask non-work related questions on the whole. And his response to me was, well, I get that you wouldn't ask that in the interview, but I always make a point of collecting my candidate from reception and also walking them back after the interview. And that's when I ask them all those kind of questions, so are you married? Do you have a boyfriend? Are you gay? Do you, whatever goodness knows what he would have asked people. So he thought that by not asking it in the interview, but by asking it outside of the interview, then that was fine. Slightly worrying, which of course it's not fine. Information prior to decision making is still information. And often it's not the question itself that is the act of discrimination. It's what you do with the answer. It's what you then go on to not give someone a job, for example. Thinking about disability for a moment, I think most employers are now aware that you legally can't ask applicants about their health during an interview. There are just a very few limited circumstances when you can, and you only can if some level of health is intrinsic to the job. So think about someone working alone at height on a building site. It would probably be a pretty sensible idea to ask people whether they have any health-related reasons or other concerns that means that they would not be able to work safely at height on their own. I think it'd be very sensible. It's intrinsic to the job. If you've got a sedentary office worker, I can't think of many good reasons that you'd be able to ask somebody a health-related question. So should a prospective employee disclose their disability to their potential employer? Well, there's no legal duty to do so, but they may choose to volunteer this information during the interview. And if they do, I would say, as an interviewer, you shouldn't then respond by asking lots of questions about it or saying, oh no, you were doing so well and now you've told me this, which of course I hope that you would never do. I would make a note of what the person says and just explain that if they're the successful candidate, that may well be something that we come back to talk about. You know, you can't put your fingers in your ears and ignore what someone says, but excessive questioning and then not giving someone a job may lead them to believe that that's the reason that they weren't successful. Candidates should, however, disclose their condition where it might pose a risk to themselves, a health and safety risk to themselves or to those that they work with. And obviously, we've got this obligation to make reasonable adjustments should we need to do so for someone with a disability. When an employee with a disability would like their employer to make reasonable adjustments for them, they will have to disclose their disability and what reasonable adjustments they think they need. Employers can't be liable or responsible for failing to make a reasonable adjustment if they didn't know or should not have reasonably known that someone had a disability. But employers are expected to do all they can reasonably do to find out if an employee has a disability. So where if you suspect that someone might have a disability, then it's reasonable to reach out and make sure that that person has been able to disclose anything that they wish to do so and that they're not disadvantaged in any way. So yeah, if somebody wants reasonable adjustments, it's sensible to ask for them, in other words. Okay. Myth number 12, we're nearly halfway through and bang on time, so that's good news. Myth 12, a woman returning from maternity leave has the right to work part-time. So does someone coming back after they've had their baby have the right to work part-time? And the answer to this one is no. No one has the right to work part-time, but everyone has the right to request to work part-time. And there's a difference between the right to have and the right to request. Although the right to request flexible working has some teeth. The flexible working concept was introduced in 2003, and it gives employees the right to request different working patterns. So it might not just be part-time. They might want to work a compressed week, so longer days, or a 9-day fortnight, or whatever. Or a different location, work from home. But it's a right to request, not a right to have. And there are legitimate business reasons to turn down a request. And I've got a slide on that in 1 second. We had some change last April. So those of you on the course, on the Employment Law Update course, you would have heard me speaking about this. So this has now become a day one right to request flexible working. It used to be that you had to have 26 weeks continuous service. Remember, that was 26 weeks from start date, not 26 weeks from end of probationary period. So now it's a day one right. Employees can make 2 flexible working requests in a 12-month period. Prior to this, it was only 1. Employers are required to deal with requests within 2 months. It used to be 3 months, unless extension is agreed. And employees don't have to explain within their application the effect that acceptance of their request might have on the business or how it can be minimised. They used to have to, they don't anymore. And employers are required to consult with an employee before they are able to refuse a request. ACAS has a fair process that you should follow when dealing with flexible working requests. So, and also you'll notice there that there's no obligation to give a right to an appeal for someone whose request has been rejected. It is recommended in the ACAS Code of Practice on flexible working, but it's not a legal requirement. I would always offer the right to appeal. Better that someone feels fairly treated than not. And this is only for employees. It's not extended to workers. And these are the reasons that you can reject a request for flexible working. They didn't change last April when the legislation changed. So there's lots of reasons that you can turn someone down should you want to, but getting it wrong can be rather expensive. So I think you just need to be pretty careful if you make a decision not to give someone the request that they've asked for. And you can consult, so you can say, I can't agree to that for these good reasons, but how about we agree to this? There was a case called Thompson and Scancrown Limited, trading as Manners, and this was a bit of a warning to employers in a case that demonstrated how important it is to consider flexible working requests really carefully. And this decision got lots of media attention because it was quite a high compensation case. And the employer here refused Alice Thompson's request to reduce her working hours after her maternity leave. And she won her claim, and that was found to be unlawful discrimination. And she was awarded just under £185,000. She was on £120,000 a year. Her contractual hours were 9 to 6, Monday to Friday. On returning from maternity leave, she had requested that she reduce her working days to 4 days a week, not 5. And she reduced her working hours so she could finish at 5 p.m, not 6 p.m, because she wanted to pick up her daughter from nursery, and the nursery shut at 5. But she was turned down on the basis that the request would incur additional cost for the business, have a detrimental effect on meeting customer demand, and they had an inability to reorganise work among existing staff. So of those, I think there was about 9 or so reasons that you could turn someone down, they brought into play 3. And this is despite the fact that this wasn't an extravagant or complicated request. So anyway, she was turned down, she appealed, she was turned down on appeal too. So she resigned, and she claimed pregnancy and maternity discrimination, harassment related to sex, that was another issue, indirect sex discrimination, unfair dismissal, and an unlawful deduction from wages, which was connected to commission payments. The only claim that succeeded was her claim in relation to the flexible working request. The tribunal found that the requirement to work 9 till 6, Monday to Friday, was indirectly an act of sex discrimination in this case, because even though that applied to all sales managers, irrespective of their sex, the tribunal concluded that women are put at what's called the children disadvantage, because women are most likely to be the primary carers for children. So they said it was unfairly and unreasonably refused, that she was disadvantaged. If they made her work till 6, she couldn't pick up her daughter from nursery. The person that had covered her maternity leave was retained within the organisation, and they were happy to help. Lots of reasons that this was unfair to have turned her down. So the tribunal essentially said, we can't see why you would be unable to cover her role on 1 day a week. The sales team was small enough to know what was going on and to be kept abreast of all potential clients and sales for that 1 day. So there you go, quite an expensive one to turn down. Next, myth 13. This is a poll question, so you'll get the ability to answer this. So you cannot make a woman on maternity leave redundant. Very simple question. Our legislation does not allow for you to make a woman on maternity leave redundant. Is that true or false? So I give you a minute to tick. I'm going to have a glass of water. True or false? Oh, quite a split here as well. So 38% of you say true, you can't make a woman on maternity leave redundant, and 62% say false, you could make a woman on maternity leave redundant. Well, the majority have it. This is false. Employers can make people redundant even if they're on maternity leave. But obviously, it's not something you would do without proper cause and giving it plenty of thought in terms of process as well. Imagine the situation where an employer actually shuts down and everyone is made redundant. It would make no difference if you were on maternity leave or not. So employers can make redundant employees on maternity leave, paternity leave, adoption leave, shared parental leave. But with maternity in particular, it also gives those employees priority over others also at risk of being made redundant when it comes to alternative employment. So what the law says is a woman who takes ordinary maternity leave, which is the first 6 months of maternity leave, they are entitled to return to the same job at the end of that leave unless the job is no longer available. Women who take and that can't be because you put someone else in it. Women who take the additional maternity leave, which is the second 6 months, they're also entitled to return to their old job unless it's not reasonably practicable for them to do so. So slight difference according to how much maternity leave someone takes. So you should assume that a woman on maternity leave will come back to work at the end of her 52-week maternity leave period, unless she tells you she's coming earlier, or of course, unless she resigns with notice. And there's similar provisions apply to employees taking adoption leave and so on. Redundancy is, of course, a potentially fair reason to dismiss someone. But in a redundancy situation, you're also required to show that you've followed a fair procedure before you make anyone redundant. So this is deciding what the pools are from which you're going to select, what the fair selection process is, what alternative employment is available, and so on. And the legislation says you should pool all relevant employees, and you should not exclude women on maternity leave or other employees from the process. So the selection process itself, it should be one where everybody is included in the same way. However, it should not disadvantage an employee on maternity leave or other relevant leave. So if, for example, absence is one of the selection criteria and you score someone on absence, you shouldn't score this person really low because they have or are on maternity leave. That should be disregarded. That's not to say that employees on maternity leave should have their scores inflated in any way. You don't need to do that, but they shouldn't be worse off in the selection process. However, as I've said, if a woman on maternity leave is selected for potential redundancy and there is alternative vacancies available, then this woman, the one on maternity leave, leapfrogs others in relation to suitable alternative vacancies. She should take priority over every other candidate not on maternity leave if there is a suitable vacancy available. In other words, if there's a suitable vacancy, she should be given it over other people, even if she's not the best person, should you have put her through a selection process. You can't just invite her to apply and then say, oh dear, you weren't the best candidate. If she can do it and it's a suitable alternative vacancy, she should get it. So you have to decide if the job is suitable, and there's conditions to whether something is a suitable alternative vacancy, location, terms and conditions, status, pay, all those kind of things. So be mindful, I think. A woman on maternity leave can be part of a pool for selection, should apply criteria fairly, and she shouldn't be disadvantaged. If there is suitable alternative employment, she should get that. Okay, what I've put on this slide, and I'm not going to go through it all because A, it's quite a lot, and B, it's quite small print. This is the Protection from Redundancy, Pregnancy and Family Leave Act, which came into effect also on the 6th of April last year. It extends the priority status to pregnant employees and those who have recently returned from maternity and adoption leave. So there is, I've specifically spoke on that myth about someone on maternity leave, but the legislation last year extends that protection further to include people also pregnant and some of these other types of family-friendly leave. So there's some detail here. Please read it at your leisure. Okay, next, myth 14. Employers do not need to do pre-employment immigration checks on British or EU recruits. So I think we're all familiar with having to do immigration checks, but do we need to do them for those who are British or EU recruits? And the answer is this is a myth. You do need to do it. Employers have a duty to prevent illegal working, and they are required to undertake pre-employment immigration checks on all staff they wish to employ to ensure that they have the right to work in the UK. I was looking at this recently for something different, and in January of this year, there was a record number of Home Office raids on businesses, particularly restaurants, nail bars, car washes, warehouses. And in fact, they made 609 arrests, and that was a 73% increase on the previous January. The civil penalties increase to £45,000 for a first breach in 2024 as well. So it's a really expensive mistake. Also, in February last year, the civil penalty for employing an illegal worker tripled. So it was 15 and it went up to the £45,000. And by the 30th of June, in fact, the Home Office issued £21.5 million in penalties once they had increased the civil penalty. But that civil penalties are not the only risk to businesses. Failing to comply can also have discrimination impact as well. If you employ someone who doesn't have the right to work in the UK, you're going to pay that fine. However, if you have undertaken pre-employment checks, you will establish what's known as the statutory defence, and you won't have to pay the fine. So if you knowingly employ someone, then that's a criminal offence, and that can even result in a jail sentence. If you mistakenly, then you've got the civil fine, but if you've done the checks, you're going to escape all of that. Certain individuals have the right to work in the UK. So we know British citizens, nationals of countries in the European Economic Area, those with indefinite leave to remain in the UK, they all have the right to work in the UK. But the UK is really ethnically diverse, and it's, I think, now impossible to tell who has the right to work in the UK by which route without first checking the relevant documents. So the only way to be sure that you've properly carried out your checks is to check everybody. And you carry out the checks as they're set out on gov.uk. It's very clear what you have to do. It should also be done before the candidate starts working for you. So you must ask them to provide you with original documentation to establish that they have the right to work. You cannot leave this until the first day they turn up for work, because by that point they have started work. And there's no, if you're found to have discriminated against someone, as we've mentioned before, there's no upper limit on the amount of compensation. So Home Office provides all the advice about what documents you should accept, and you can find that on gov.uk. I would imagine ACAS also has that set out for you too. You've got to retain copies of those documents on file. So there's lots of checks and a process that you must follow. Okay, myth 15. It is not possible to have a contractual retirement age anymore. So I hear this one all the time. Oh, there's no such thing as a contractual retirement age. Well, the answer is that's not true. There is still the ability for an employer to have a contractual retirement age, but it's again something that you would be very thoughtful and mindful for before you put a default retirement age in place. So retirement is still a potentially fair reason to terminate someone's employment, even though in 2011 the statutory retirement age was repealed. However, if you want to have one, you need to be very careful before you set one in place, and there's lots of hurdles to get over first. Requiring an employee to leave against their will is, on the face of it, potentially age discrimination. And there's lots of cases in the UK and in the EU, in fact, that have shown that it's possible to to unfairly dismiss someone on the grounds of age discrimination, but it's also possible to justify a company retirement age on either the whole or part of a workforce, provided the employer can firstly show a legitimate reason for doing so, and that the age selected is a proportionate means of achieving that legitimate reason. So part of the analysis is, are there any reasonable alternatives? So you need to be pretty careful. What's the right reason? What's the right age? What would be a reasonable alternative? And if only after all of those questions are analysed, would it be safe to impose a company retirement age? So there's been a case recently in March. An employment tribunal unanimously ruled that this big law firm, Walker Morris LLP, had unlawfully discriminated against a senior partner when they forced them to retire at aged 63. So this was where this former equity partner of this large law firm won the employment tribunal claim, saying that they'd been forced out at 63. And this, the claimant here is Martin Scott, and he worked for this firm since 1990, equity partner in 1997. And the tribunal heard that the firm's policy was that partners aged over 60 had to reapply to stay on in the firm. And they had that obligation to do something called intergenerational fairness. Basically, they said their legitimate aim was that they wanted progression opportunities for younger people to come in and make partner. So whilst Scott was successful in his first application to stay on after 60, they said, we will permit you to do so as you provide exceptional contribution. A few years later, when he applied to stay on again, he was turned down, and he was therefore made, he was put out of work at aged 63. So the tribunal sided with him, with Mr. Scott, and they said that this was age discrimination. They said the refusal to grant the renewal amounted to less favourable treatment. They said that the policy they had was not a proportionate means of achieving a legitimate aim. There was no evidence, according to the tribunal, that the firm needed to free up equity in order to give progression opportunities to young partners, and therefore their legitimate aim was not justified. So you do need to be pretty careful. That the remedy hearing is yet to take place, so I don't know what this person will be awarded. But you know, I think it's one of those things, if you want to have a company retirement age, you can, but I would take some pretty good advice before you put one into place. Health and safety, it's a lot easier to justify. But yeah, I mean, the alternative, of course, is that, you know, if someone isn't performing, that they go through whatever fair process you've got. You know, say they've worked on a very long-standing older member of staff, and you've noticed a deterioration in performance. That's what we've got underperformance and capability policies for. So deal with it in that way. Focus on what their performance is, not what you think the reason for their underperformance might be. I was working with a very well-known, very posh London store just recently, and they told me their oldest employee was aged 93. So there's good reason that people can work on for lengthy periods of time if they want to. Okay, myth 16. Having a good and well-known anti-harassment and bullying policy would show that an employer is doing all they can to prevent sexual harassment of employees. So if you've got a great policy and it's well known, is that enough to show that you are preventing sexual harassment? The answer to that is no, it's not enough. Employers facing a claim by an employee that they've been subjected to sexual harassment at work often think, if they've got good policies and everyone knows about it, that that's enough, but it isn't. That would see someone falling short of doing enough. And the reason employers want to make sure they do enough is because there is an option when it comes to discrimination for an employer to pass on the liability for an issue to individuals that they employ and escape the liability themselves if they've taken all reasonable steps to eliminate discrimination. And this is the concept of vicarious liability. And that says that if an employer does everything reasonable, then they can escape the liability should there be a claim. And whoever did whatever the thing was is personally therefore liable. So when people bring discrimination claims, they tend to list their employer as respondent one, and then whoever did whatever they're complaining about as respondent 2, 3, 4, whatever. So it might say British Gas PLC, then their line manager if they had done something wrong, someone in HR if they didn't take their complaint seriously, a colleague if they harassed them, and so on. People are individually named. And there was a case a few years ago now, Alley UK Limited and Gellon, where this chap worked as a senior data analyst for this claims management company. And he had 10 months of employment, and he became the focus of what the employer tried to describe as racial banter due to his Indian origin. Now, I don't think you can connect those two words and that'll ever stand up. Once you call something racial banter, I think it becomes slightly difficult in an employment context to justify that. The definition of banter, or the one I always use, is that banter is the reciprocal and mutual teasing exchange of jokey comments between friends. Reciprocal, teasing, jokey friends. Anything that relates to a protected characteristic, I don't think can be identified as banter. That is risk-free from upsetting someone. So with this, you don't really need the details of this claim, but basically there were lots of very unpleasant comments, jokey comments made regularly to this claimant, Mr. Gellon, including things like, well, at least if you ever get made redundant, there's a lot of corner shops around here you could work in. Comments about how he dressed, the colour of his skin, the fact that he drove a Mercedes. Oh, don't all Indians drive a Mercedes? And why are you in the country at all? All the unpleasant comments. And this was said regularly in front of colleagues of his. So it wasn't one-to-one, it was said in small groups. And there were company managers that either overheard or aware of these racist comments, and no one took any action to challenge or stop the behaviour. So when it came to the tribunal, the employer tried to argue that we've got great policies and we regularly update them and everybody knows about them. We even do training and we educate people. So we shouldn't be liable. The liability should shift on to the individuals. And even though they attempted to run that defence, the tribunal decided that they hadn't taken all reasonable steps and they stayed liable. And this was partly because they said the training was tick box in nature and stale. It had taken place more than, I think it was 2 years ago, wasn't regularly refreshed, and was just a kind of online tick box type exercise. And secondly, they said, and it also hasn't worked because people are hearing it as well as doing it and no one's stopping it. So the training isn't even working. You've even had managers know what's happening and they've taken no action. So if you're going to, try and have this liability escape route and say, okay, why should we be liable for a rogue employee doing something wrong? You've got to, not only have great policies that are well known, but you've also got to have good training and education that's regularly refreshed and works. And your managers have to jump on issues and deal with them. So there's proof that it's embedded in the culture of your workplace. And from the 26th of October last year, again, I definitely mentioned this in our last employment law update, we also had the new statutory duty. This is called the Worker Protection Amendment of Equality Act of 2023, that says employers must take reasonable steps to prevent sexual harassment in the workplace. And if they don't prevent it, then there can be a 25% uplift. This is purely about sexual harassment. So this obligation to prevent has real teeth because obviously it has a compensation element in a successful claim. Good. Okay, myth number 17. An employer must accommodate needs arising from a religious belief as they would needs arising from a disability. So you must accommodate needs people present as arising from a religious belief, just as we know you have an obligation to look at reasonable adjustments for a disability. And the answer here is not entirely simple, but I would say it's yes, you should where possible. All employers should take steps to try and make sure religion or belief discrimination doesn't happen at work. It is unlawful for an employer to discriminate against a member of staff because of their religion or belief, as it is for any of the other protected characteristics. Protection, remember, is also afforded to the non-believers. They have the same right to no less favourable treatment as believers. You know, people might want time away from work for various reasons. They might want time away to pray. They might want time for religious festivals or religious services. You know, there's no legal requirement for you to give additional time, and there's no legal requirement for you to give facilities. But where possible, you should try to accommodate any requests in a way that fits in with your business needs. So in other words, it can be discrimination if you unreasonably refuse. There's that word reasonable again. You know, if someone requests time to pray during the day, you know, consider how you can be flexible. Can you maybe have them start work a little earlier or finish a little later? Could you let them shorten their lunch break so they can take breaks at other times in the day? You know, what can you do to accommodate, to help somebody? Maybe when it comes to time off for festivals and services, you know, you might not say that can take priority, but you might encourage people to book the time off that they want early, well in advance, or you might agree how to handle it where two people want the same time off. So, you know, think about how you're going to deal with it. Also, unexpected events such as funerals need to be looked at with sensitivity. In some religions, you know, burial or cremation takes place very soon after death, so employees might not be able to give much notice. And I thought I would just remind you of what are the 9 protected characteristics under the Equality Act of 2010. These are all here, remember, historically, because certain groups of people with specific protected characteristics did experience discrimination in the past, and that needed legislation for the future. And that's the reason why we've got protection in all these areas. There used to be 116 separate bits of discrimination type based legislation, and that all got merged into one single act. The first legislation we had dates back to the Equality Act of 1970, sorry, the Equal Pay Act of 1970, and then we had the Sex Discrimination Act in 1975, right through to age discrimination, which was the last protected characteristic in 2006. So I thought it would just be good or worthwhile to have a quick reminder of that as well. In fact, my mum was someone that was discriminated against a very long time ago. She was in the marriage and civil partnership type of discrimination. And she said she worked for the post office. I think it was the post office, it was a civil service job anyway, or public sector job. And she got pregnant sorry, she got married. God, twisted that story far too early. She got married while she was working for the post office, and all the lovely celebratory, did a collection, decorated her desk, all very nice. And also the post office dismissed her because they dismissed women who got married. It was called the marriage bar. And even though that sounds like some weird nightclub where you know, go along and find your life partner, it was in fact the practice of dismissing people when they got, or women when they got married. So we've had a lot change over the years, but that's the reason that we have legislation that we have, because there was discrimination. Right, actually, it makes sense to stop at this point before we go on to look at the last few. So let's have another 5-minute break, because I'm sure if we finish slightly earlier, you'll be happy. So if we come back just after 11 o'clock, we'll carry on and deal with the last few myths I've got for you. So have a quick comfort break now, and I'll see you in about 5 minutes. Thanks very much. Hello, everybody. Hopefully that's enough time for a quick break. So we'll plough on and deal with the last few for you. So myth 18 is where we are. A resignation must be put in writing and accepted by the employer before it will take effect. So a resignation must be in writing and must be accepted before it takes effect. Well, that is also a no. It's another common misconception that an employee's notice of resignation has to be written and is not valid until it's accepted by the employer. The position at kind of common law is that a notice, once clearly given, is effective and can neither be refused by the employer or withdrawn by the employee without the other's agreement, other than in a few specific circumstances. We often write and say, in response to someone resigning, we accept your resignation. But in reality, we can't actually say we don't accept it. We can't write, sorry, that really doesn't work for us. You'll have to stay and work here forever. Generally, unless the employee's contract of employment stipulates that the resignation does not take effect until it's put in writing, there's no requirement for a notice of resignation to be in any particular format. And I would, if it's verbally given, I would confirm it back in writing just so you've got clarity. I've also thought it might be worthwhile talking about where the difficulties arise. If an employee tells you that they're resigning, but it's as a result of some sort of heat of the moment issue or argument, then is it clear that they're actually resigning, or are they just sounding off? If someone says like, that's it, I can't take this anymore, and storms out of the room, is that a resignation? So you need to be pretty careful if there's some sort of heat of the moment type issue. Give the employee opportunity to withdraw a resignation, even if they're clear and say, I can't work here, I'm leaving. Give them that chance to withdraw a resignation once they've cooled down. It's always good practice to put that offer to think again in writing, so you've got evidence of the fact that you did give time to reconsider, just in case there is a later dispute. Once an employee has resigned, then both parties should know what notice is applicable and when the employment relationship will come to an end. And then there's all the practical stuff you'll want to figure out about annual leave and benefits and so on. Employees sometimes give their employers no notice at all, or a shorter period of notice than they're contractually obliged to. But an employee is only entitled to do this if they're resigning in response to a fundamental breach of employment terms. So that's a constructive dismissal, in other words. In normal circumstances, if you're not willing to accept a shorter notice period, then you simply write back to the employee, explain what they're required to give as contractual notice. If they refuse to work it, then it's not a great deal you can do. You only obviously pay them up to the date they actually stop working. I mean, it is technically a breach of contract. But, would you want, if someone gives you 2 weeks less notice than they should give, do you want the pain of, taking them to court for a breach of contract? Once you've received notice of resignation, I think, it's good practice to be really clear about what happens next. Are they working it? Are they on gardening leave? Do you have the right to put them on gardening leave? All those kind of things. In this case, Bradley versus the Royal Mint, an employee resigned. They announced their departure to colleagues, but 3 weeks later, they asked to withdraw their resignation, stating that they'd had a mental health crisis. And however, the employer refused, and this led to a disability discrimination claim where the tribunal had to decide whether the employee was legally able to withdraw her resignation. So directly relevant to the myth, basically. So this lady is Sarah Bradley. She worked for the Royal Mint for a long time, 2009 to 2022, and she'd been the HR director there since 2015, so a senior role. She did have depression, anxiety, she had ADHD, and she had previously attempted to resign from her role a number of times. And the tribunal heard this included a board meeting where she exploded and had an emotional breakdown. The chief executive did not accept any of the previous resignations, or, rather than not accept, she was talked out of them and she stayed. Many of this was recognising that she was unwell. However, we go forward to June 2022 and she resigns again. And this time, instead of talking her out of the resignation goes through. However, she wanted to change her mind and she was concerned about her future. But this time, the CEO didn't allow her to reverse that or rescind that resignation. The Royal Mint had already started looking for a replacement, and they claimed that she had made plans to go and work somewhere else. So she brings a claim and says the organisation discriminated against her for taking her previous threats to resign into account when they were all made in relation to her disability, and that they should have not allowed this resignation to stand. The Royal Mint, in response, claimed that they had a legitimate aim of not allowing her to rescind her resignation, because they said it was destabilising for the senior management team. They'd started to look for someone else. They believed that she was off to earn more money elsewhere, and that the reason she had resigned was not related to her medical conditions at the time. Anyway, to cut a long story short, she won, and the tribunal decided in her favour. This is called a Section 15 claim, and it has two stages to it. First of all, the person has to show that they were treated unfavourably because of something arising from their disability, or in her case, disabilities. And the tribunal here accepted medical evidence that her mental state was significantly impacted by medication changes at the time of her resignation and her health. So her disability was linked to her resignation. The second thing the tribunal has to consider is whether the employer's actions, i.e. not allowing her to rescind it, were a proportionate means of achieving a legitimate aim. And the Royal Mint argued that allowing a senior manager to regularly, resign, to then rescind her resignation after she had publicly told everyone she was leaving, was all destabilising for the workforce. In fact, on that point, the tribunal agreed that that was a legitimate aim, but they found the employer's actions were disproportionate. And they said, even so, even though that is a legitimate aim, you should have paused the process to have obtained proper medical evidence, got an occupational health report before deciding how to proceed. So you didn't do enough. And she won. So there we go. We have to think carefully when people resign in the heat of the moment, or resign and say, I didn't mean it. I was having a health related issue that contributed to that. It's where there's difficult circumstances surrounding someone's resignation, and a cooling off period, checking in with someone to see whether or not they actually want to resign is the right thing to do. As a general rule, normally when an employee resigns in clear and unambiguous language, you can take it at face value. It's only where words aren't clear, or you find yourself with a situation such as this, that you would need to take those additional steps. Okay, myth 19. You cannot lawfully dismiss a genuinely ill employee. So this is a bit like you can't dismiss a pregnant person. The answer is yes, you can. You can dismiss, but you would be very careful, especially if that genuinely ill employee has a disability. And many employers are quite rightly nervous of dismissing staff who are genuinely ill, even if they've been off sick for a very long time. And I think you're right to be careful. And often we're worried about doing it on compassion grounds, someone's individual situation of being dismissed as well as whatever else they're trying to cope with is pretty difficult. But it's also a commonly held belief that you can't sack someone because they're ill. So the tribunal always looks at what's the reason for the dismissal and is there a genuinely fair and reasonable reason. And long-term ill health is a genuinely fair reason to dismiss someone, and they don't get special protection. But you have to be careful where the dismissal is linked to a disability. Also, if you have permanent health insurance, it's very difficult to dismiss people who are in receipt of a PHI benefit. You should definitely take advice before you consider doing that. So you can dismiss, but you need up-to-date medical evidence as to what the prognosis is, how much longer the employee is likely to be off, when they're likely to return, whether there's disability, what adjustments might be made to enable someone to return. Lots of things to consider before you would ever move to dismissing. Reasonable adjustments is a cornerstone of preventing disability discrimination. That can even include transferring to another job. So fair procedure has to be followed. Ideally, you have this in a sickness absence policy that says how you might move to dismissing people with repeated short-term absences as well as long-term absences. So while it's possible, you would be very careful before doing so. I thought I'd put up here the definition of a disability in the Equality Act: a physical or mental impairment which someone has or has had, which is substantial and long-term and adversely affects their day-to-day activities. So there's no list of conditions that are deemed a disability under the Equality Act and no list of ones that aren't. It's much broader than that. We often think of, disabilities as being people that are wheelchair users or people with a hearing or sight impairment, but it is much broader than that. The definition includes the word substantial, and substantial is defined as more than minor. It includes the word long-term, and long-term is defined as 12 months or something that's predicted to last for at least 12 months. But lots of conditions are covered on diagnosis, even where there's no impairment to that person at that point in time. So, for example, someone with, HIV or skin cancer might have no impairment or adverse effect on their day-to-day activities, but the condition is progressive and therefore protected from point of diagnosis. So often people are protected immediately. Okay, on a lighter note, there's one case that sticks in my mind. It's quite an old case. It's in 2008, and it's where a teacher claimed that they'd been discriminated against on the grounds of their disability and related the condition to baldness. And this teacher claimed that he had been bullied by students by being bald, and that his employer had not done enough to protect him and look after him. And the tribunal disagreed that being bald was a disability and said that that's not baldness, it doesn't constitute an impairment. And the judge noted that by the same logic, if you had a big nose, you would argue that it was a disability too, which seemed like a slightly flippant thing to have said. Feel slightly sorry for that teacher. But baldness has found to be harassment on the grounds of age, though. There has been a baldness case where an employee was successful in saying that that was age-related harassment, so not disability. Okay, I think we have another poll question. Myth number 20. As long as I give notice under the contract, I can terminate an employee's employment on the day before they reach 2 years continuous service without fear of an unfair dismissal claim at the employment tribunal. So as long as you give notice under the contract, you can end someone's employment the day before they get 2 years continuous service without risk of an unfair dismissal claim. So take a moment and decide if you think that one is true or false. Okay, answers in. Oh, a very good split again for this one. So 45% of you think it's true that you can do that without risk of an unfair dismissal claim because they wouldn't have 2 years service. And just higher, 55% of you said that is false. Well, the 55% have it on this occasion. It's not true. It's a common misconception that if an employee does not have 2 years continuous service, they could be dismissed the day before without need of a fair reason or process. Of course, notice only applies in some circumstances. I've mentioned this already. If you're terminating for gross misconduct, then there's no notice obligation at all. However, you do still need 2 years service to bring an unfair dismissal claim. So the reason for the dismissal would still be relevant. If the reason is discriminatory in any way, then that 2 years service obligation doesn't apply because, as I've said before, no minimum service is needed for a discrimination claim. The same is true if the reason for the dismissal is something that's called an automatically unfair dismissal. Then just like discrimination, you don't need 2 years service. And I have put on the next slide what some of the automatically unfair dismissal reasons are. There are 60 different automatically unfair reasons where 2 years service isn't needed. So this isn't all of them, but this is some of them. So acting as a union rep, I'm just going to pick out a couple. Being a part-time or fixed-term employee, asking to be paid the national minimum wage, like asserting any statutory right, going on jury service, whistleblowing, taking action on health and safety grounds. So lots of reasons why the 2 years service wouldn't apply. When you want to dismiss fairly, you've got to have a combination of one of the 5 potentially fair reasons to dismiss, plus a procedure that's fair and reasonable in the circumstances. So you have to have a substantive fair dismissal and a procedural fair dismissal. And those are the 5 potentially fair reasons. A statutory ban, I think conduct, capability and qualification redundancy, probably all relatively well known and straightforward. Conduct is either gross misconduct or progressive misconduct, i.e. gross, we can only let you do this once and then we'll dismiss you for it. Progressive, you've been late, you've been given a written warning, you've been late again, you've got a final written warning, you've been late again, you're now dismissed with notice. So conduct, gross or progressive. Capability and qualification, this is where your sickness absence dismissals fall and your underperformance dismissals fall and the loss of qualification dismissals fall. You need a driving licence to be a lorry driver. You no longer have a driving licence. On the grounds of qualification, we can terminate your employment if we can't find you another job. Redundancy, I think, is straightforward, where there's either no employment left, the company has gone under, has finished, or we've got less people and we're making selections as to who to make redundant. Statutory ban is where under some other legislation it's illegal to now employ someone. So a very obvious one is if someone doesn't have the right to work in the UK any longer. And then the SOSR dismissals, this stands for some other substantial reason. Maybe it's a restructure that doesn't result in redundancy. The fire and rehire dismissals I mentioned earlier, that's an example of a SOSR dismissal. So if you don't have one of these reasons to dismiss, then the dismissal will always be unfair, even if you follow what you say is a fair process. So once you've established which one of the 5 potentially fair reasons it is, you then go through your fair process. If it's misconduct, you're going to have investigated, you're going to have invited that person to a meeting, you're going to let them defend themselves, you're going to have maybe given warnings and so on. So whatever the reason is, you follow the fair procedure. Also, if you wait until the day before the 2 years, that's going to be too late anyway, as the tribunal adds on something that's called statutory notice in calculating the length of someone's employment. So in cases where the employer terminates the employment, either with or without notice, the effective date of termination can be extended to determine if the employee has enough unfair dismissal notice, i.e., do they have the 2 years, by adding on an extra week. So, for example, if you dismissed someone the day before their 2 years and paid them in lieu of notice, the tribunal would still add on 1 week, and that would tip them over the 2 years. If you dismissed someone and gave them no notice, you just said, I'm dismissing you, then the tribunal would add on 1 week for the effective date of termination. So if you get rid of someone the day before, you're in difficulty. If you dismiss someone a month before and you give them a month's notice, and that month's notice expires just before the 2 years, then that's fine because you gave them proper notice. It's where you try and do it all just on the cusp of the 2 years that you've potentially got difficulty. Okay, so always worth remembering that the effective date of termination is often another week. It's also worth mentioning that the law is changing. We've got the Employment Rights Act of 2025 on its way. Changes are afoot when that passes in 2026 and in 2027. And I'll go through this in February when we have our employment law update. But one of the changes coming is that the right to claim unfair dismissal will apply regardless of length of service. So it will be a day one right. It's likely to have what's called an initial period of employment, an IPE, which is essentially going to be for the first time a kind of statutory probationary period. There's still debate about how long that will be, whether it will be 6 months or 9 months. But this, in the IPE period, probationary period, there will be some sort of modified dismissal process. So it will be easier to dismiss. But the right to bring an unfair dismissal claim will apply from day one. So we're going to be looking at policies and procedures and processes to ensure that there's a fair, we've got a fair defence to any unfair dismissal claim. Okay, myth 21, an employee whose fixed term contract comes to an end on the day agreed cannot bring an unfair dismissal claim. So another poll question for you. If you have a fixed term contract and it ends on the day you agreed with the person it would end on, then they can't bring an unfair dismissal claim. Is that true or is that false? Second term, have a think. We've been pretty split today on what people have thought, so yep, fairly split on this one too. So 61% of you think it's true. An employee whose fixed term contract comes to an end on the day agreed cannot bring an unfair dismissal claim, and nearly 40% of you thought that was false. So the answer is it is no, as there can be circumstances when ending a fixed term contract on the date you agreed can still give rise to an unfair dismissal complaint, or even worse, a discrimination complaint. So even though that sounds illogical, you would think it'd be true that an employee whose fixed term contract comes to an end can't claim unfair dismissal, but it's not. And a fixed term contract obviously terminates automatically at the end of the fixed term. And in common law, there would be no dismissal and no breach of contract. But what happens if you still need the work to be done? So the fixed term contract comes to an end and you don't invite that person to continue, but instead you go out and recruit someone else to do that work. Well, that person might say, why? Why not me? And look for whether there's a discriminatory reason for that decision. But could they bring an unfair dismissal complaint? What if you thought, remember, this has to be at least 2 years because you need to have 2 years service at the moment. I've told you that's going to change, but at the moment you need 2 years service to bring an unfair dismissal claim. What if they just weren't that good and their performance had been deteriorating, but you can see the end in sight because there's an end date to their fixed term contract? So why bother go through the pain of a process? Let's just let it end and get someone else. Well, as long as they've got 2 years service, they have the right to be treated fairly. And if the reason you're not renewing them for the work is because of their performance, then you should have followed a capability or underperformance process. So you're in more difficulty. Now, if someone has nowhere near 2 years service, it's a 3-month fixed term contract. As long as it's not discriminatory, they can't bring an unfair dismissal claim. So think about the duration. How long is this fixed term contract? And remember, if you've given a series of fixed term contracts without the requisite break, they will become continuous periods of employment. So what's the duration? What's the reason that you want to not renew this person? Imagine they've got 2 years service. It's a lengthy fixed term contract, or you've renewed it twice, and now, it was 2 18-month periods of fixed term employment. They've got over 2 years service, but actually there's just no more work for them to do. It's naturally coming to an end. The project is finishing. There just isn't the work. Well, that's a redundancy. And with someone with more than 2 years service is entitled to redundancy pay and a proper redundancy process. So you'd be at risk of a breach of unfair dismissal legislation by reason of redundancy. So think, how long is the fixed term contract? Has there been any renewals? Does that tip them over 2 years? What's the reason? Should we have followed a fair process? What's the notice? Should we have made sure that they had proper notice before the fixed term contract came to an end? So lots of things to think about. It's not as easy as the contract's coming to an end. That's the end of the process. Good. And I've mentioned to you notice already, and this was just to remind me to speak to you about notice. I mean, one further thing probably worth a mention is you have to well draft fixed term contracts, because if you forget to put in any notice, if you want to end it early, you have to pay up to the end of the fixed term contract. So if there was no notice clause, it would be implied that you would pay the full duration. So if you had a 6-month contract and you tried to end it at 3 months and you've got no notice in there, you're going to have to pay the whole 6 months up front. So it's really important to have early termination provisions in a fixed term contract, because reasonable notice is not implied in fixed term contracts, and the omission could be very expensive for an employer. So make sure you've got early termination drafted. Okay, myth number 22. I think this is a poll question as well, but I've lost my list. Oh, yes, it is. Without proof, we can still dismiss. For example, we have had a theft, and it can only really have been one of 2 employees, or both of them for that matter. We can dismiss them both if we can't identify who it is. So without proof, we can still dismiss. If we've had a theft and we don't know who of 2 people it is, we can dismiss both of them. So true or false? Take a second and let me know what you think. See if we've got another split. We do. A much clearer split this time. So 18% of you say true, without proof, you could still dismiss, and 82% say false. Clearly, you're saying you need proof and you couldn't dismiss 2 people when you didn't have proof. Well, the minority have it this time. The 18% are right. This is true. You can, without proof, still dismiss if you can't decide between 2 employees. Now, it sounds really tough, doesn't it? But there was a case that always reminds me of this particular case, Moni and Coral Racing. And this was where the Court of Appeal actually went through several appeals. They held that if an employer reasonably believes that one of 2 or possibly both employees have been involved in dishonesty, but it's been impossible to determine which of them is guilty, it was reasonable in this case to have dismissed them both, as long as you can show that you acted reasonably in all the circumstances. Really tough call, but the burden of proof is not, beyond all reasonable doubt. there's a difference in employment law on the burden of proof than there is in criminal law. You know, when it comes to something criminal, you have to have, it's a 99.999% proof. You have to have beyond all reasonable doubt. With employment law, you have to have a reasonable belief. It's a much lower test. We're not the police, you know, we can't fingerprint, we can't do all the things that you'd be able to do in a criminal case. And that's why, as long as you've got fair process, you've properly investigated, you've done your best, and you've got a reasonable belief that you can defend, then in this case, it was fair to dismiss 2 people. And you know, the strange thing would be that even if you got to the tribunal and both people were there, and one person had an absolute attack of the guilt and said, you know what, I did do it. I feel like, you know, this person has been unfairly dismissed and I've got to own up. That would still be 2 fair dismissals because you're only judged on what you knew at the time. So it still wouldn't overturn and make that an unfair dismissal because you can only be judged in the tribunal about what you knew at the time you made a decision. So there you go, very tough. But it just reminds, hopefully it reminds you that the burden of proof is a lot lower when it comes to employment law than it is elsewhere. Good. Okay, I've got just 3 left to go. Myth 23. An employee can rely on covert recordings in an employment tribunal. Is that true or false? So can an employee rely on covert recordings in an employment tribunal? Nice, simple, short question. Take a second and make your decision. True or false? Okay, another split. 40% say true that they can, 60% say false they cannot. And again, the minority have it for this one. True, they can. Recording a conversation, and I've sat on cases where I've listened to covert recordings myself. Recording a conversation in secret is not a criminal offence and is not prohibited, even though everybody says it is. As long as the recording is for personal use, you don't need to obtain consent or let the other person know. Under data protection legislation, this is for individuals. Under data protection legislation, you should only take covert recordings if the purpose is to prevent or detect criminal activity or malpractice in the workplace. So it's not as simple as you go around recording who you like, when you like. You've got to, A, it's got to be for personal use, and B, under data protection, you should only do so if it's to prevent or detect criminal activity or malpractice in the workplace. And so accordingly, a private recording can be submitted as evidence. Of course, the court has to give permission. And as I said, I've sat on cases myself where we've heard covert recordings. Even in those cases, the court will still consider whether the covert recording was necessary and whether the information could have been collected in a different way. But employees do secretly record internal meetings with their employer, and generally those recordings may well be accepted if they're relevant to the case during an employment tribunal hearing. So I always say to people, hold all your meetings with the view that you might be being recorded. Lots of employers have very clear rules that say that they do not permit people to make recordings, and I'll come on to what you can do to protect yourself in a minute. There was a case, Punjab National Bank International Limited and Gossain. And in this case, Miss Gossain recorded a private conversation between her employer's rep after she'd left a meeting room following a grievance hearing. And that recording, so she wasn't even in the room, that recording contained very degrading and sexually discriminatory comments about her. And she was able to have that admissible as evidence as it was considered relevant to the claim. So that prevailed over the confidentiality of the employer's private deliberations. So you can see more readily where if someone records a meeting that they're a party to, but this was an example where someone recorded a meeting and they weren't even in the room at that point. I've got clients that will say to people, phones have to be turned off, bags have to be left outside. There's lots of ways that you can maybe account for this. So what can we do? This case is another good reminder. Phoenix House Limited and Stockman. Can we take misconduct or gross misconduct action against an employee who records people when we tell them not to? Because lots of people put it in their policies that it is misconduct to record meetings. Everybody owns a smartphone these days, or pretty much everybody, and each one of those is a recording device. So it's becoming increasingly common and far easier for employees to covertly or secretly record meetings or discussions. In this case, the Employment Appeal Tribunal confirmed that whilst in most cases a covert recording will amount to misconduct, whether it amounts to gross misconduct will be considered on a number of factors. So I think, in other words, it's easier to say, covert recording would be misconduct. It's harder to say covert recording would be gross misconduct. So I think you should definitely indicate whether you allow meetings to be recorded or not. I certainly, when I conduct workplace investigations for clients, it's one of the first things I say, that no permission to record the meeting is given to you or for anyone to listen in or record the meeting on your behalf. And I can't continue until you confirm that no recordings are taking place. I think it's quite common that is, the good practice that people have in investigations and other meetings. It's often also put into policies and procedures. But when somebody does covertly record, does that undermine the trust and confidence between an employer and employee? And I think you'd need to look at what was being recorded. Was it in breach of policy? Was it in breach of being reminded? What was the purpose of doing that recording? Was the employee trying to entrap the employer or put them into a vulnerable situation? There's lots to consider about as to whether it could be pushed from misconduct to gross misconduct. Anyway, make sure you state no recording in your policies and procedures. Make sure it's in your disciplinary policy too. At the start of relevant meetings, remind people. Think about whether you want phones switched off, bags outside. Bear in mind that even covert recordings can be produced. So run all your meetings, even when the employee is not in the room, as if you are being recorded. That's probably the safest way to go. Okay, then just as an aside, what is the date of a summary dismissal? So when you dismiss for gross misconduct, you dismiss without notice, and that's called a summary dismissal. What is the date of a summary dismissal when the outcome is reserved and given in writing? So if you had a hearing and it's gross misconduct and you find against the person and you tell them they're dismissed without notice, but you don't tell them at the time, you say, I will put my decision in writing. What is the actual date that they are dismissed? So is it the date when the hearing took place? Is it the date on the letter? Is it the date the letter is posted, if it was posted? Is it the date the letter is delivered or received? Or is it the date that the letter is read? And it is the last one. It's the date when the letter is read, which is a little bit out of your control if you don't have some way of having a notification as to when something is read, signed for, email opened or whatever. And there was a case a few years ago where somebody was dismissed. Their letter was sent by recorded delivery to their home address. The person was on holiday. They didn't open the letter. By the time they came back from the holiday and actually opened the letter, they had tipped into having 2 years service and was able to bring an unfair dismissal claim. So all because they were able to prove that they were away and did not open that letter until this date. So if you want to be sure someone knows they've been dismissed, you need to tell them. Okay, 2 to go. Myth 24. Employers must provide a reference if requested. I hear this one all the time, actually, that when someone sends in for a reference request, you have to comply. And I've also heard people say if the reference request has lots of tick boxes and gaps for you to fill in answers, you have to complete that. And both is not true, or at least not always true. So by law, you don't have to give a reference unless A, you have committed to giving a reference in writing. In the contract, for example, it says that you will give a reference. Or B, you've agreed as part of a settlement agreement that you will give a reference. Or C, for certain types of jobs, you've got an obligation to give a reference. So financial services jobs regulated by the Financial Conduct Authority, or even I think the Prudential Regulation Authority, you are required to give a reference. So the answer is no, unless any of those circumstances apply. And then last question, last poll, myth 25, you cannot give a bad reference. So yes or no, short answer. Can you give a bad reference? Give you a second to answer that. Thank you for doing the polls, by the way. It's really helpful. Here we go. Oh, another good split, quite even split. So 57% of you say it's true, you cannot give a bad reference, and 43% of you say false, clearly meaning you can give a bad reference. So again, the majority are right here. It is false. It's not true. You can give what reads like a bad reference if it's true and accurate and not misleading. If a reference is unfairly negative, then, of course, the employee may seek to claim compensation in cases where it's cost them a valuable job opportunity or they've had a job offer withdrawn, like we were talking about earlier. Equally, for a new employer who has wasted recruitment costs in reliance on a positive but misleading reference, they too might seek to recover their losses from the employer who provided the inaccurate information. So you have an equal duty of care when you give a reference to both the person you're writing about and to the employer you're sending that reference to. Often employers follow Ronan Keating's advice. You say it best when you say nothing at all. We've already said that you don't have to give a reference other than in a few limited circumstances. But what about the situation where you dismiss an employee for theft, but you don't actually mention the reason they left on the reference? They then imagine they're then employed with the next company and they go on to steal from them too. Could you be liable for those losses as your negligent misstatement means that they employed someone they otherwise wouldn't have employed? And these types of claims, although very rare, as a matter of best practice, they are possible. So it's always best to avoid any statements that are likely to expose you to a risk of litigation. Even if the employer is able to defend the claim, it can be costly and time consuming. So really think carefully about what you want to say in a reference. Of course, if you're giving good references, and 99% of the time you probably are, you have nothing to worry about. It's where there are difficult circumstances. It's also important to ensure that any statements you make are not in any way discriminatory. So, for example, if you said, yeah, this person was great, but they were off sick a lot because they had cancer, that could put off the next employer and therefore be a discriminatory issue for you, as a claim is likely to be brought on those grounds. So be pretty careful what you say, but it is possible to give what reads like a bad reference if it's true. So with these risks in mind, often employers give what I call a tombstone reference. It's the minimal information that you might find. Their name, their job title, the date they started, the date they left, and that's about it. Often banks, building societies, insurance companies give pretty minimal information. although a prospective employee is still able to obviously check the information against whatever the candidate has put in their CV or application form. So you can do this. I think there's no issue with it. But even if, if there is an issue and there is a problem, then you do need to think about whether it's giving a factual explanation for someone's reason for leaving is the right thing to do. And I think this is my last slide. This was a case, Jackson and Liverpool City Council, where the Court of Appeal found that a former employer was not in breach of its duty of care when it gave a reference which referred to an uninvestigated allegation against a former employee. And that reference was found to be true, fair, and accurate in the circumstances, and they were not negligent. That's because they stated that there was an uninvestigated issue that had yet to be considered before the employee resigned and left. So factual, true, but obviously pretty damaging. But they made it clear it was uninvestigated, and therefore no outcome was reached. So there we go. Follow the rules. Main rules when it comes to references: ensure the reference is true, fair, and accurate. Bear in mind your duty to both employee and employer. Take reasonable care. Make sure it's not deliberately disparaging or doesn't sabotage an employee's chance of getting another job. And that's it. Let me just check the questions. So I've got one question left unanswered. Can you ignore a reference request on an employee that was dismissed for gross misconduct to avoid giving a bad reference? Well, you can, bar my point about if they employ that person and then they repeat the gross misconduct, could that give rise to a damages claim against you? So you would need to, I would probably even consider getting some good advice on that before you make a decision as to whether to ignore that reference request or not. As I said, there is that risk. And that's it. Thank you all so much indeed. I've really enjoyed putting this together for you. I hope it's been useful. A few reminders. Thank you for doing the polls. It makes such a difference. And I've enjoyed being with you today. So thank you very much. Have an enjoyable Friday and a lovely weekend. And I will see you again in February. Take care.